because for all those reasons, those regulations are unconstitutional, and the public is clearly being duped here.
What is going on with the government's health regulations? Well, joining me to provide some clarity is Stuart Hayward. He is an advocate at the Johannesburg Bar. So Stuart, welcome back to the show. We had you on a couple of weeks ago explaining the draft regulations to the Health Act. We'll link to that video here, as well as to your original Business Day article. But what is happening now with these interim regulations regarding COVID? Could you help us to understand?
David, what happened on Wednesday, the 4th of May, was that the government gazetted a notice which did two things. The first of which was the extension of the comment period associated with the draft regulations that you and I discussed in our previous interview, and the draft regulations that are the subject of my Business Day article. Those regulations are subject to a 90-day period from the 4th of May, which allows the public to comment up until the 4th of August, 2022. The notice also included a provision for the publication of regulations in terms of the National Health Act, which are permanently applicable. Now, those regulations apply to mask wearing, outdoor gatherings, and the transit in and out of the country associated with vaccination certificates. Now, what those provisions are really just a copy and paste of the transitional provisions within the Disaster Management Act, which were applicable from the 4th of April up until the 4th of May. So this was predictable in the sense that government was never going to leave a lacuna in the sense that no law regulating COVID-19.
All right, so what we're speaking about now is separate to the health regulations that we were referring to in our previous video. And so this refers to this kind of interim stage. But now it seems like there's almost a bit of a duplication happening here. Is that correct?
Yes, David, that's correct. And I think that is the important thing for the public to understand is there are draft regulations, which are the subject of our previous discussion. They are not yet law, those draft regulations. And they are permanently applicable regulations that were published, gazetted on the 4th of May, on Wednesday, which are permanently applicable. They are not subject to comment. So there's a distinction between draft regulations and published regulations. Published regulations become law the moment they are published. Draft regulations are subject to comment. So the public can still comment on the draft regulations that we had discussed, but there are certain provisions regarding masks, etc., that are permanently applicable, which the public cannot comment on. And there is a duplication, David, and I think that is one of the biggest problems with the notice that was published on Wednesday, is that the government has effectively deemed permanent the very regulations that are part of the draft regulations. In other words, the public has now got 90 days to comment on the draft regulations, but the government has in a rather sinister fashion, in my view, simply published regulations in the National Health Act without the need for comment, which the minister may do. The minister has a discretion to publish regulations in the National Health Act with comment or without comment. And the minister has simply made certain regulations permanent. So all of the aspects that I raised of constitutional breaches of constitutional rights in the previous video and in my Business Day article, they apply without question to the regulations that are now permanent, because we have in the regulations that are now permanent, the minister has a discretion as to decide when the regulations apply or not. In other words, when the COVID restrictions apply, without the need for to consult medical doctors, without the need to go to Parliament, without the need for expert evidence. You know, we're sitting with a really what is, or I would describe on the government's part as a Kansas City shuffle, an attempt to dupe the public via these regulations, via giving the public 90 days to comment. In other words, oh, hooray, we've got more time to dispute this. But I think what the public perhaps doesn't realize is that there are now permanent regulations which apply indefinitely, which are pretty much a duplication of the draft regulations.
All right, Stuart. Well, we are showing here on the screen the National Health Act, and Section 94 says that the minister must publish all regulations proposed to be made under this act in the Gazette for comment at least 3 months before the date contemplated for their commencement. But then section 94C says that the minister may, if circumstances necessitate the immediate publication of a regulation, publish that regulation without the consultation contemplated in paragraph A. So it seems there that is a direct contradiction in a way, or a bit of a loophole where the minister may just impose the regulations willy-nilly.
Precisely, David. Generally speaking, when ministers publish regulations, draft regulations, in other words, for comment, they are regulations which the minister is well aware, the government is well aware that the public may have issue with them. In other words, that comment is required. That's precisely where the Kansas City Shuffle comes in, because the government has given the public 90 days to comment on draft regulations, whereas it has used the discretion in section 94C to publish them immediately, which begs the question, and it makes it patently obvious to me, David, as a practicing advocate, that these regulations, I agree that there is a contradiction. And how can the government, on the one hand, quite rightly give the public an opportunity to comment on regulations that breach their constitutional rights, but on the other hand, the government makes permanent some of the very regulations which are subject to the draft regulations. Now, what the government probably should have done in this case, David, is extended the transitional period regulations under the Disaster Management Act so that they only applied for 30 days or they only applied for 90 days. That would have been a cogent approach. But what we sit with now is permanently applicable regulations. And that is what I underlined in my Business Day article in the previous interview, was how obviously dangerous this is to give a minister such wide, unfettered powers of discretion.
So, Stuart, do you think that the government is potentially open here to a legal challenge? Could you see civil society actors launching legal proceedings?
David, I would be very surprised if there was not a legal challenge to the regulations that were gazetted on Wednesday, the permanently applicable regulations, for the very reason that I've just underlined. I'd be very surprised if that didn't happen, because for all those reasons, those regulations are unconstitutional, and the public is clearly being duped here. And the NGOs in South Africa are well funded, they are well respected, and I have no doubt that they will launch a strong legal challenge. And then the government will be in a situation where it probably has no other option but to repeal the regulations that were published on Wednesday and allow the 90-day period to run its course, and then use the Disaster Management Act. That's, as I said before, that's probably what the government should have done, because importantly to understand, the Disaster Management Act regulations are temporary in nature. National Health Act regulations, once promulgated, are not temporary, and that's the big problem with the regulations that were promulgated on Wednesday.
Right. So, Stuart, how can the public add its voice to the consultation process? Because we still obviously have that 90-day window on the draft regulations.
David, the public should go to dearsa.org.za, and which is a very convenient online portal. It takes literally 2 minutes to comment. You check some boxes. It's very, very easy and convenient. And I think, David, the fact that the government did extend the period for comment shows that the outcry and the comments that have already been made are effective. And that's important for the public to remember. This fight is not over, and the public plays an important role in that fight via those comments.
Stuart Hayward, thank you very much. Let's hand over to you, our audience. What do you make of these latest health regulations? Please comment down below. Also, don't forget to like this video and subscribe to the channel if you haven't done so already. That will mean that you are alerted to all of our weekday videos, which come out every morning at 6 a.m. That's it from me, David Ansara. Until next time, take care.